Imagine that your 15-year-old son just got home. He's upset and angry because a police officer stopped him while he was riding his bicycle through the park. He was on the way home from school and he kept to the paved paths in the park. But the police officer gave him a citation because he said that your son violated a town ordinance that says, "No vehicles shall be permitted in the park." Has your son actually broken the law? Well, that all depends on what the law means by vehicles. Is a bicycle a vehicle? If it is, then it seems like your son has unfortunately violated the ordinance. But is it obvious that a bicycle is a vehicle? If you live in a dictatorship where the government can punish you at its whim, then that's not the kind of question you're likely to ask. It probably doesn't matter that you might have a plausible argument that you didn't break the law. But in countries like the United States, where the government is supposed to be subject to the rule of law, it matters what the law says. If the law doesn't ban bicycles from the park, then your son can't be punished for riding one in the park, even if some policeman thinks that it should be a crime. But how are we supposed to know what the law prohibits? Sometimes this is a challenge because we're simply unaware of the law. Do you keep close track of the laws enacted by your local town or city council? What's more, many legal requirements today are issued by administrative agencies that many citizens have never heard of, let alone paid close attention to. But let's put the problem of ignorance of the law to one side. Imagine that in your son's case, there was a big sign posted outside the park that clearly said, "No vehicles shall be permitted in the park." We still need to interpret the law to figure out whether it bans bicycles. Interpreting statutes and regulations and understanding the rules by which the government adopts them and courts apply them is the subject of a typical first-year law school course on legislation and regulation. The course is a relatively recent addition to the first-year curriculum. Pretty much all the other courses taught in the first year, torts, property, and contracts, for example, are primarily common law subjects. Under the common law system, which the United States inherited from England, courts devise rules to resolve the cases presented to them, and they look to the reasoning and opinions from previous cases for guidance on how to decide new controversies. It's these judicial opinions that students of torts, property, and contracts spend much of their time reading and discussing. Law schools still focus heavily on common law decision-making in the first year because analytical thinking, which is what you learn by studying the common law process, remains the coin of the realm in the practice of law. But the common law process is no longer the central feature of our legal system. Instead, law today is more likely to be enacted by a legislature or promulgated by an administrative agency than it is to be declared by a court. That doesn't mean it has any less authority, though. It can govern everything from the taxes you pay, to the medicines you can buy, to the quality of the air you breathe, to what procedures the police have to follow if they want to arrest you. And if you want to figure out how to comply with a statute or a regulation, or challenge one, or help a client do the same, you need to know how to make sense of statutes. So let's return to your son's predicament. We shouldn't fume pointlessly about the citation that the police officer gave him. We should try to figure out whether a bicycle is a vehicle. Where do we start? Well, one option is just to look in the dictionary. After all, our question is about the meaning of a word. Here's how one of the most commonly used dictionaries defines the word vehicle. It's a means of carrying or transporting something, or an agent of transmission. It can also be a medium through which something is expressed, achieved, or displayed, or an inert medium through which medicine is administered. We can quickly dismiss the third and fourth dictionary definitions of the word vehicle. Common sense suggests that the ordinance doesn't ban pain relief tablets or mutual funds from the park simply because they're vehicles for administering medicine or making money. The first and second definitions of the word are a means of carrying or transporting something and a carrier. A bicycle is pretty clearly both of these things. It's a means of carrying or transporting a person from one place to another. Seems pretty straightforward, right? Well, look at the examples that the dictionary gives of vehicles. Planes and trains, motor vehicles, other pieces of mechanized equipment. These things are different from bicycles. They're not only bigger, faster, and more powerful, they have motors, and bicycles typically don't. So maybe the dictionary definition doesn't really resolve the question whether a bicycle is a vehicle. Perhaps we should just answer the question about the law's meaning by referring to the word's ordinary common sense meaning. What's the ordinary meaning of the term vehicle? When you hear the word vehicle, do you think of bicycles? If someone asked you how many vehicles your family owns, would you count your bicycle along with your cars? Probably not. But what if this issue had arisen not because your son got a ticket for riding his bike through the park, but instead because you had just gotten knocked down in the park by a 20-something courier who zipped by on his bicycle? Would it be so obvious in that case that there'd been no violation of the ordinance? But maybe we've been asking the wrong question. We've been considering what the word vehicle means in ordinary usage, but the word appears in a town ordinance. So perhaps instead, we should be asking what the town council meant when it used the word vehicle in the ordinance. Notice how the two inquiries are different. It's possible that a bicycle is, strictly as a semantic matter, a vehicle, but that it's not a vehicle for purposes of the ordinance. Conversely, most of us wouldn't think of a bicycle as a vehicle, but it might nevertheless count as one of the banned vehicles because the town council intended to ban bikes from the town's parks. Thinking about the question this way might help to explain why just a few minutes ago we said that we can safely ignore the dictionary definitions that refer to a means of administering medicine. Our intuition is that members of the town council couldn't possibly have meant to ban pain relief tablets from the park. But other than the words of the law and common sense, how do we know what the town council meant? This question highlights an important difference between courses that cover common law subjects and courses that focus on statutes and regulations. Students in subjects like torts, contracts, and property learn to read judicial decisions and then to make arguments about why the reasoning in a prior case mandates a particular result in a new case. But statutes usually don't include reasoning. They don't ordinarily explain why the legislature addressed a particular problem or what the justification for the regulation was. Whereas judicial opinions announce rules and reasons, statutes tend to announce just rules. If judicial opinions are novels, then statutes are poems. They're brief, but packed with meaning. So how do we discover that meaning? Imagine that the law was enacted after two elderly park goers were injured when they were struck by bicycle couriers riding recklessly through the park. In that case, the context for the enactment of the ordinance suggests that it was a response to the problem of bikes and parks. There's a strong argument, given the context, that the town council intended to ban bikes and that the members of the council used broader language, the word vehicle, to make clear that it's not just bikes that are banned, but cars and motorcycles and so forth. But imagine instead that the town council enacted the law after two highly publicized incidents in which people who were trying to avoid traffic jams rode motorcycles through a downtown park, both resulting in serious injuries to parkgoers. Would that change our understanding of what counts as a vehicle? At a minimum, that might make us feel more confident that a motorcycle is a prohibited vehicle under the ordinance. But would it tell us anything about the status of bicycles? Sure, you could argue that the town council was worried about motorcycles and other motorized vehicles that have the potential to cause serious injuries to persons who are struck by them, and that a bicycle isn't such a vehicle. But the town prosecutor can respond by noting that the prior incidents show that the safety of pedestrians in parks is threatened by fast-moving things on wheels, and that the town council, by using the broad term vehicle, meant to ban all of them. In other words, sometimes the context for the enactment of a statute will tell us something about what the legislature intended when it enacted it, but often the context, like the law's language, will be susceptible to multiple interpretations. So what else can we consider in trying to figure out what the town council intended when it enacted the ordinance? Well, suppose that the minutes of the meeting at which the town council adopted the law are available. The council took up the proposed ordinance after the motorcycle accidents that I mentioned a moment ago. At the meeting, one member of the council proposed a bill that would have said, "No motorcycles shall be permitted in the park." Another council member responded by noting that by singling out motorcycles, the language might imply that other, more dangerous vehicles, like cars, are permitted in the park. And so the first council member amended the proposal to read, "No vehicles shall be permitted in the park." But then yet another council member argued that this broad language might be read to include bicycles and other non-motorized and largely non-threatening vehicles. He moved to amend the language to read, "No cars, trucks, or motorcycles shall be permitted in the park." The second council member responded by arguing that bicycles can be dangerous to parkgoers too. The first council member, conversely, said that she didn't think that the word vehicles includes bikes. The council then voted 3-2 against the amendment, and then voted 4-1 to adopt the bill that simply says, "No vehicles shall be permitted in the park." Now, what does this legislative history tell us about the meaning of the ordinance or about the council's intentions? On the one hand, it suggests that the council was concerned about more than just motorcycles. But it also suggests that the council was not of one mind about bicycles. One of the council members suggested that bicycles are dangerous and arguing for the proposal with broad language. But at least two council members seem to think either that bicycles shouldn't or wouldn't be included. Part of the problem is that the town council isn't a monolithic organization. It's a collection of several, in our case 5, individual people, each with her own preferences, intentions, and understandings. As a political scientist once famously put it, a legislature is a they, not an it. Some members of the council seem to think that bicycles should be banned from the park. Others didn't. Some didn't share their views on the question at all. And then the council chose language that doesn't clearly resolve the issue. Unfortunately, this isn't unusual. And our example involves just a one-line ordinance enacted by a 5-member council addressing one issue. Imagine if instead it had been a 500-page statute enacted by 2 houses of Congress and signed by the president, addressing hundreds of issues. Of course, conscientious legislators can take steps to forestall interpretive difficulties. Our hypothetical ordinance is quite brief, and as a consequence, it leaves lots of questions unanswered. But could the town council address the problem by making the law more specific? Well, suppose the text of the ordinance we've been considering was actually just Section 1 of the ordinance. Section 2 states, "For purposes of Section 1, a vehicle is any mechanism for conveying a person from one place to another, including automobiles, trucks, motorcycles, and motorized scooters." Would drafting the law this way answer our question? Well, we have the same problem we noted in using a dictionary definition. On the one hand, a bicycle is a mechanism for conveying a person from one place to another. On the other hand, all of the listed vehicles in the ordinance are motorized. Does that mean that a mechanism must be motorized to count as a vehicle under the law? Perhaps not. The ordinance says that the definition includes those types of vehicles, which means that it presumably applies to things that are not on the list too, and so possibly bicycles. So imagine instead that Section 2 defined vehicle in the manner we've stated and then added, provided that bicycles shall be allowed in the park so long as they are pushed or carried and not ridden. That would take care of our interpretive problem, though it would also mean that your son was properly cited for riding his bike in the park. But it wouldn't take care of all interpretive problems. Suppose that it wasn't your 15-year-old son who was cited for riding his bike in the park, but instead that you received a citation when your 4-year-old granddaughter, whom you had taken to the park, rode her tricycle fast down a hill. Would the definition section give us sufficient guidance to resolve that case? It's not clear. It depends whether the ban on riding bicycles necessarily implies a ban on riding tricycles. It turns out that even when we make the statute more specific, we can still imagine situations that wouldn't be clearly resolved.